Major breaking news out of the United States Supreme Court. The Supreme Court has just agreed to hear its Second Amendment case this term, and the term is very young. This is a question of whether or not federal law that makes it illegal to possess a firearm if you're an unlawful user or addicted to a controlled substance, whether or not this ban on firearms possession is consistent with the Second Amendment. What do I think about this? We have to talk about it when I come right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, folks, so here's the story. The U.S. Supreme Court has just granted cert to another Second Amendment case this term. The Supreme Court had already granted cert in the Wolford case out of the Ninth Circuit, which deals with the so-called vampire rule or the no-carry default rule. That was just granted cert a few weeks ago. Now today, breaking news, the U.S. Supreme Court has just agreed to hear another Second Amendment case. It has granted cert in the case of Ali Daniel Hammani versus the United States. Now, what is the question presented and what do I think about it? The question presented is whether federal gun control statute 18 U.S.C. 922 G3, which is the federal statute that prohibits the possession of firearms by any person who is an unlawful user of or addicted to any controlled substance. The question is whether or not that federal statute is consistent with the Second Amendment's right to keep and bear arms. Now, let me cut to the chase. The Second Amendment 100% is going to lose in this case. 100% the Second Amendment is going to lose in this case. There is a 0% chance that this Supreme Court is going to rule that people that use drugs, including but not limited to cocaine, heroin, marijuana, it doesn't matter. 100% chance this Supreme Court has got 5 votes to say that if you're a regular user of these substances or you're addicted to these substances, then consistent with the Second Amendment, you can be disarmed. That is going to be the outcome. Okay? That's the reality on the ground. So the only question presented in this case, as I see it, in terms of what you should care about, that you can affect and change. Okay? I'm not saying you shouldn't care about the outcome. But I'm not here to tell you what I want, by the way. I'm here to tell you what the reality on the ground is. And I have to give you the diagnosis as I see it, and what you do and how you think about it is up to you. But the reality is they're going to find that 18 U.S.C. 922 G3 is consistent with the Second Amendment, and it's perfectly fine as a matter of Second Amendment law. That will be the conclusion. So the real issue here that we in the Second Amendment community have to concern ourselves with is how do we lose this case? How does the Second Amendment lose this case? That is very important because as I've explained to you before, there's 2 important parts to every Supreme Court case. One is who wins the case. Very important, of course. But the second part, or the second thing that's so important for the Supreme Court case, in some ways more important than the first, is how the party wins or loses. It's the rationale, it's the reasoning. And in this case, this is all we should care about. And I say this because the methodology, the approach to how the Supreme Court applies Bruin in this Ali Daniel Hammani case is going to be something we have to live with in other gun control challenges or Second Amendment challenges to gun control. So I'm going to tell you how I think the Supreme Court's going to rule in terms of the methodology in just a moment. Before we go there, though, I want to tell you why I don't like the fact that the Department of Justice sought cert in this case. And I know why they did it. And I think it was a strategic error, but I could be proven wrong. I might be wrong. There may be something else out there that's all going to be fine. But it's pretty clear to me that this Department of Justice has a general view of the world, and it's not a crazy world, or not a crazy worldview. And what I mean by that is, I think it's pretty clear this Department of Justice views that if you're a law-abiding American, you're not a criminal, you should have full-blown Second Amendment rights in all respects, and they're going to defend those rights right up to the end. On the other hand, because this Trump administration doesn't like criminals, and nor should we like criminals. We've talked about why we shouldn't like criminals as a general matter either, right? This administration is a law and order administration. They support the police over criminals. They're not going to be building memorials and holding, 5,000 person funerals for drug addicts who die. That's not going to be happening. Okay. And that's actually not a bad thing from our perspective, because as I've explained to you, the best arguments for the anti-gun movement against the Second Amendment are when criminals are on our streets engaging in psychopathic, insane, terrible behavior, misusing firearms. When the psychopaths use firearms to shoot up a school, when some criminal uses guns to kill a bunch of people on a street, this gives rise to calls for more gun control law and to get rid of the Second Amendment. So we in the Second Amendment community do not want to support criminals, especially violent criminals, as a general matter. We do not generally want to support psychopaths that are mentally ill and violent as a general matter. We need them to be put away, locked up, taken off our streets, because if they're locked up and off our streets, they cannot do terrible things with guns. That gives rise to calls for more gun control. So it's not crazy that this Department of Justice under Donald Trump and Pam Bondi want to fully support Second Amendment rights on the one hand, but also be tough on crime on the other hand. That is consistent with the view that our society is not a libertine society where anything goes. It's really an ordered liberty society where there's full-blown liberty, but there are rules of the road that you have to follow. My concern with this case, and you'll see why in a second, is that the Supreme Court is going to rule in favor of the gun control law, and they're going to say that the gun control law is consistent with the Second Amendment. My concern is the way the court goes about rationalizing and making that conclusion under the Bruin methodology of text first, burden shifting to the government, historical tradition of firearms regulation has to be found and proven by the government. My concern is, and I'm not saying this is going to happen, I'm just telling you it's a concern, is that when the Supreme Court finds this law to be constitutional, which they will, they're going to loosen up the Bruin standards and make it easier for the anti-gunners and the government to justify modern-day gun control laws. I'm not saying that's going to happen, by the way. I'm saying that is a concern that we want to be worried about to make sure that doesn't occur to the extent we can affect that change. That's all I'm saying. Now, what I'm going to do now is I'm going to give you the facts of this particular Mr. Hammani, who is really another version of Rahimi in a sense, and you'll see why in a moment. And then I'm going to tell you how I think we probably will lose this case and why it might be okay to lose this case the way I'm going to describe. So first of all, let me give you the facts about the criminal defendant here, because remember, this is a criminal defendant. And as I've explained to you, there's two types of cases that go to the Supreme Court as a general matter involving the Second Amendment. One is civil cases brought by people like Dick Heller, great Americans, who in the case of Dick Heller was allowed to carry his gun during the day as part of his job in Washington, D.C., but when he went home, he was denied the ability to have a handgun. A law-abiding, upstanding American citizen going to the court to vindicate their Second Amendment rights is what we want. That is the fact pattern we want every time in front of the Supreme Court. What we do not want is another Zaki Rahimi, which is going to the Supreme Court, fighting over the Second Amendment with some scumbag psychopathic nut job. So Mr. Rahimi, on that record, admitted to taking his girlfriend's head and bashing against the dashboard and then shooting at witnesses, and then admitting that all this is true and that he was a danger to society under oath in court. That is not a fact pattern we want to see go to the Supreme Court, in my view. That is a fact pattern that the anti-gunners, the Merrick Garland, the Joe Bidens, the Kamala Harrises of the world want to go to the Supreme Court with. Those fact patterns. So with that dichotomy I've just drawn, that we want to go to the Supreme Court with people like Dick Heller, right? And the Bruin plaintiffs. We don't want to go to the Supreme Court with criminals. Tell me which side of the aisle you think Mr. Ali Daniel Hammani falls. Well, according to what the DOJ says that indicted him and charged him under the statute, he's a dual citizen of the United States and Pakistan. So now we're in front of the U.S. Supreme Court on behalf of a guy who's a citizen of Pakistan and the United States. His actions drew the attention of the FBI. In 2019, a search of his phone at the border revealed communications suggesting that Mr. Hammani was poised to commit fraud at the direction of suspected affiliates of the Iranian Revolutionary Guard Corps, a designated foreign terrorist organization. So why are we in the front of the United States Supreme Court on a Second Amendment case involving a Pakistani citizen who was connected, according to the evidence, supposedly, to designated foreign terrorist organizations like the Iranian Revolutionary Guard Corps? The only reason why you bring a case like that is you want to make sure you win if you're the government. And that's going to happen. And I won't bore you with all the other details about this guy, but this guy's parents traveled to Iran to participate, and he did too. He and his parents traveled to Iran in 2020 to participate in the celebration of the life of Qusson Soleimani, an Iranian general and terrorist who had been killed by American drone strikes. Again, not the poster child for going to the Supreme Court involving Second Amendment cases. It's just not, right? It's just not. You want to win for the government and the crime? This is the guy. Well, needless to say, this guy, at some point, he turns out he was a drug dealer. He used illegal drugs. He used marijuana, and it turns out, I believe, cocaine as well. And he admitted to all this. So he's a cocaine user. He's a marijuana user. He's a drug dealer affiliated with designated terrorist organizations associated with Iran. And he's a Pakistani citizen. And he was charged by a grand jury for a crime where he possessed a firearm because he was also found with guns. So he was charged under this federal statute, 18 U.S.C. 922 G3, prohibited person statute, for possessing a firearm while being an unlawful user of or addicted to a controlled substance. And the Federal Court of Appeals threw this case out on the grounds that there's no historical tradition of preventing disarming people that use drugs, to make a long story short. I won't bore you with those details in this particular video. So that is the guy who is going to be arguing in favor of our Second Amendment rights, Mr. Hammani. Is that a good thing for us? I don't think so. No, I don't. But that is the case that the Department of Justice asked for cert in, and the Supreme Court granted cert, which we knew was going to happen. I explained this in, at both the Second Amendment Foundation events and the Gun Owners of America events. That was going to happen because you have a circuit split on the question of whether or not unlawful users of drugs or users of unlawful drugs can possess firearms for various analytical reasons. And there's a circuit split there. And if you have a circuit split over a federal law, and the Solicitor General of the United States wants the Supreme Court to hear the case and resolve the case, they're going to ask for that, and it's going to be granted cert like 99% of the time. Now, I understand the argument here is to say this is not going to be a hard case to rule against the criminal bad guy, against the baddie. And the reason why it might be true that this is not going to be a terrible case to rule against the baddie is because in some ways, all the Department of Justice is going to do in this case, and all the Supreme Court is going to do in this case, is simply point to Rahimi and say, look, the Supreme Court has already said that if you're a violent danger to someone else and presumably to yourself, there's a historical tradition of disarming people like that. Under the founding era surety laws, that says that there's a finding by a court of dangerousness, that you're a dangerous person, then you can post a surety, and that is an example that if there's a finding that you're dangerous, the government can take steps to ameliorate that danger. Likewise, at the time of the founding, you have these long-standing affray laws. And affray laws are basically if you go out into public with a weapon and you terrorize the public with a weapon, guess what? You can be put in prison. And all that's going on here, I think, is the Supreme Court will say is the following. They say, look, under the surety laws, as we pointed out in Rahimi, and under the affray laws, if someone turns out to be a physically violent danger to themselves or to someone else, they can be temporarily disarmed while they're in that condition. Here, I think the Supreme Court is going to say, is the statute says that if you are currently, listen carefully, I want you to be very nuanced here, folks, to be the smartest person in the room. The Supreme Court is going to say, I suspect something like this. If you're arrested with a gun, and while you have that gun, you are indeed an unlawful user or addicted to a controlled substance as defined by Congress. And those controlled substances, marijuana, cocaine, crack, heroin, whatever it is, those controlled substances, Congress has made a clear decision based on the science that if you're a user of those drugs, that is dangerous. That is physically violent, dangerous to yourself and or to others if you're on those drugs. And I think the court is going to say that if you are a current user, an unlawful user of these drugs, or you are addicted to these exact same drugs, and you possess a firearm, we can put you in prison. Under the surety laws at the time of the founding, if there's a finding of dangerousness, we could force you to post a surety. If at the time of the founding you are found to have terrorized people in public with a firearm or any weapon, we can put you in prison. Therefore, in light of this, we can take the middle ground. I think the Supreme Court will say Congress can take the middle ground and disarm you because you sort of fall in between the founding era surety laws of posting a surety on the one hand and going to prison. And if all we're saying is if you're an unlawful user of or addicted to these controlled substances, you can be disarmed under federal law as a prohibited person while you are an unlawful user, while you are addicted. If you cease to be an unlawful user of the drug today, if you cease to be addicted of the drug today, tomorrow you can possess firearms. See what I'm saying? So I think the Supreme Court is going to view this sort of as a temporary disarmament law in the same way they viewed the Rahimi case. Because in Rahimi, as you recall, they said, look, if you are found to be a danger in court after due process, while you are a danger subject to that restraining order because you're a physically violent danger, while you are found to be a physically violent danger, you can be temporarily disarmed for that period of time, assuming there's a court finding. Now here, the Supreme Court, I think, is going to say the same thing. They're going to say, if a jury finds specifically that you, the criminal defendant, were an unlawful user of the drugs, were addicted to those controlled substances, and at the same time you were in that dangerous condition, that physically violent, dangerous condition, either dangerous to yourself or to someone else, that moment in time, if you also possessed a firearm, that's not allowed. That violates the law. And that's consistent with the Second Amendment. And then they may also throw on, on top of the surety and affray laws from the founding era they relied on in Rahimi, they may also simply point out that at the founding, it was well understood that lunatics and idiots could be disarmed. Lunatics and idiots could be handled in some way. Lunatics were really the psychopaths that were dangerous to themselves and to others. The idiots were really, I think, the mentally retarded, is the way to think about that, mentally disabled. See what I'm saying? So at the time of the founding, you had the lunatics and the idiots, as defined at the time of the founding, okay? So I think that you're going to blend those things in with the surety and affray laws, is my guess, and they're going to be like, yeah, if you're currently using these drugs illegally, if you're currently addicted to these Schedule I drugs, you can't have guns during that time period, that temporary period where you're doing this. That is what the Supreme Court is essentially going to find, I suspect. So again, do I love any of this? I don't. And I'll tell you the reason why I don't love this. It's not that I think the DOJ is necessarily screwing this up in terms of anything per se, but my concern is there are other better Second Amendment cases out there to be taking today. And if I were the Department of Justice, I would be pushing more sympathetic Second Amendment cases to the Supreme Court rather than pushing Second Amendment cases to the Supreme Court where you're going to lose in favor of the Second Amendment. And yes, I understand you want criminals to go to prison. And I'm sure this is the balancing act that DOJ is considering. They want law-abiding Americans to have their guns, and they don't want criminals to have guns because it's those same criminals that will go out and do terrible, bad things and screw up the Second Amendment. So I do understand the logic here, but I might not have pushed these pot cases, these drug cases to the Supreme Court so quickly. That's just my strategic take. Doesn't mean I'm right. A lot can happen. We'll know a lot more at the end of this term. It may all work out for the best, but I'm just telling you, I am nervous about this case. I'm not freaking out about the case, but I'm nervous about it as to what ultimately happens. I think we'll be okay, but I got to tell you, it's not risk-free. So anyway, let me know if you agree or disagree with some of my comments down below. Again, thanks for tuning in. Make sure you follow me over there on X at 4 Boxes Diner. Don't forget to subscribe both to YouTube and to Rumble. I look forward to talking again real soon here at the 4 Boxes Diner.
Orders up. Table 2A.